Discuss the admissibility of evidence. Admissibility evidence is any document, testimony, or tangible evidence used in court of law. Evidence is usually introduced to the judge and jury to show proof of point in case. Judicial notice is defined as an acknowledgement of the fact to the judge without explicit confirmation in the form of testimony or tangible evidence being presented. It is a substitute for evidence. If a judge asks the rule of admissibility of evidence before a trial is called motion of limine. The reason for this ruling is to prevent inadmissible evidence from contaminating the jury. Once the court has made a definitive ruling, a party does not have to renew an objective or even give any proof to show its ability to claim an error on appeal. The admissibility to the piece of evidence, there are standards for renewing the admissibility of evidence, though. They are technical rules of evidence, kind of like hearsay rule, where a judge may consider any non-privileged information regardless of whether that underlying information would be admissible, and the question is to weigh under the preponderance of evidence standard. There is also conditional relevance determinations. For conditional relevance, the court has only to consider evidence that would itself be admissible and make its decision based on whether a reasonable jury could find the condition fulfilled. Admissible evidence must be used to win a case, that is, to prove a defendant's guilt beyond a reasonable doubt. Relevant evidence is defined by FRE 401. For that evidence to be admissible in court, the evidence has only to show the existence of the fact consequence more probable or less probable than it would without the evidence. Evidence is not relevant, is not admissible. However, relevant evidence can be inadmissible if the evidence has no logic relevance. Excuse me on that word. The evidence could be excluded. If evidence seems prejudice or aggregate, the jury could be excluded. If evidence is shown to be the jury, it could be confusing or cause so many ways of thinking of the issue, it would be considered a waste of the court's time and most likely be excluded too.